Welcome to the October 8th Zoning Board of Adjustment meeting. Some housekeeping items. If any member of the audience wishes to speak to an item on the agenda, there are speaker request forms to the left of the dais. Please fill out a request form with the agenda number on the item that you wish to speak to and hand it to the secretary. Cell phones and electronic devices. At this time, we would like to ask that any member of the audience that has a cell phone or other electronic device that you either turn it off or turn the signal to silent. If you need to take a call, please step out to the hallway so the meeting will not be disrupted. And first item that I'd like to bring up is we have a new alternate serving on the Planning Commission, and his name is Mark Jobman. We welcome him today. Okay. I'd entertain a motion to approve the September 24th, 2015 Zoning Board of Adjustment minutes.
So moved. Second.
Motion's been made by Steve and seconded by Jan. All those in favor, please say aye.
Aye.
Opposed? Motion passed. Item number 2.
Item number 2 is 15 VA003, a request which has been revised since the first time we took a look at it. It was originally a request to reduce the minimum required side yard setback to an attached garage from 8 feet to 5 feet. Over the last few weeks, the applicant has worked with staff to revise the request to be a detached garage. I'll start with the presentation. Its property is located at 4021 West Chicago Street. This is aerial showing there was previously an attached carport located on the east side of the property. The applicant their original variance request was to replace that carport, which had to be taken down, with an enclosed garage, and it would have a 5-foot side yard setback. Future land use plan shows the property's low density neighborhood. West Chicago Street's a principal arterial street. Property is currently zoned low density residential district 1. This is the original request. Hard to see. Right here is the attached enclosed garage, which would have a 5-foot side yard setback. After working with their neighbor to the east and with the fire department and staff, they came back with a revised request to construct a detached garage behind the house with an overhang on this side. There's the distance increases between the structure to the east. There's more room for light, air, aesthetics, maintenance on the properties on either side. The comprehensive plan for low-density neighborhood recommends that garages be de-emphasized, so when you're coming in with a request for an attached garage with a reduced side yard setback, it makes it a little bit more difficult to support. This one is de-emphasizing that garage. This is a photo looking at the property to the north on West Chicago, to the east, to the west. Location where the carport used to be was off the edge of the roof. You can see it's pretty close to the house next door, and where that gate is in the back is where the pad ends and where the proposed detached garage would be located. Looking into that area back there, and this is a picture of the neighbor, I believe, to the west that also has a detached garage. That was one of the things when we were reviewing this originally, that to say that in keeping with the neighborhood, you'd have a detached garage. So staff's original recommendation on this was to deny for many reasons. Staff is now, for the detached garage, would recommend approval with further reasons as noted. So the applicant is here to answer any questions. Are there any questions for staff at this time?
Motion's been made for approval. Is there a second?
Second.
Karen seconded. Steve made the motion. All those in favor, please say aye.
Aye.
Opposed? Motion passed. Item number 3, please.
Item number 3 is 15 VA004, a request to reduce the minimum required front yard setback from 25 feet to 0 feet. In June, well, let me get you located. This was continued from the last Planning Commission meeting due to lack of quorum. The request is this shows the original structure on the property. And June 17th, 2014, the Zoning Board of Adjustment approved a reduction in the front yard setback to West Rapid Street from 25 feet to 5 feet. Staff did not recommend or did not support that request at that time. However, the Zoning Board of Adjustment did approve the request. Property is located West Rapid, St. Ange Street. Mixed-use commercial just north of West Main. We have urban neighborhood to the north where there's some single-family dwellings. West Main's a principal arterial, but West Rapid and St. Ange Street are not identified. Property is currently zoned general commercial district, so you'd have a 25-foot setback from streets. And you'll see it's medium density residential to the north. Here's a site plan, kind of difficult to see, but these are the lines of the structure as it was constructed. So in June 2014, Zoning Board of Adjustment approved a request for a reduction in the front yard setback from 25 feet to 5 feet. When the structure was actually built, it encroaches 1.9 feet into the right-of-way. So this is difficult. It's something we were looking at and said, is this a deal we can make? We made it, and now we have to clean up the issue. So not only are we having to do another variance to reduce the front yard setback, but at the previous Planning Commission, we approved a vacation of right-of-way for that 1.9 feet along the entire property in this area. Site plan showing parking, landscaping, and the structure encroaching 1.9 feet into the right-of-way. That's pretty close to the sidewalk. Elevations, sign package submitted. This is the original exhibit from the vacation of right-of-way. It goes from one end to the other now, and that revised exhibit has been submitted with utility concurrence letters. This is a picture of that addition. It's right up on the sidewalk. This is the existing parking. The structure to the east, which has a non-conforming setback. Looking east on West Rapid. Single-family residential to the north. This is looking north on St. Ange Street, more residential. To the west, more residential. Properties to the west. Over here we have commercial on West Main Street, and looking at north on St. Ange. The other issue that was decided with the previous variance was to allow parking located on this side to back into the right-of-way. It was existing parking, and they needed it to count towards the expansion as proposed, and west side of the building. Staff did not support the original variance request. The minimum adjustment has been set at 25 feet to 5 feet. However, if zoning board is going to recommend approval, we'd recommend with the stipulations that it's contingent upon the vacation of right-of-way being approved by City Council, and that would be going on October 19th. And the variance be granted for the existing structure only, and that any redevelopment of the site be required to have the 5-foot setback that was approved with the original variance request. The applicant is here. If there are any questions, are there any questions for staff?
I see none. there a second?
Madam
Motion-
Chair,
Yes.
so if we could get Mr. Rollinger to cite the reasons for the approval, just so that we're ensuring that we're meeting the criteria for review of a variance, such as that this allows reasonable use of the property, such as that due to the fact that the vacation of right-of-way was approved by Planning Commission is going on to council, that since the city doesn't need that right-of-way, the encroachment should not be injurious to the neighborhood.
Include that in my motion.
Karen has a question.
Thank you. I am going to vote in favor of this because of the alternative is kind of strict. But I am surprised that the contractor didn't realize how close he was to the sidewalk and realize that there's a setback there. And so I'm just saying that I think there's been a lot of those that happened in the past, and we need to make sure that people have good site plans and something that's a legal site plan that we know we stick to. And so I'm going to support the motion, but I do think that we need to be more cautious in the future.
Amanda?
Thank you, Madam Chair. And I guess, may I address a question to Vicki, please?
Yes.
Vicki, this is just a general discussion. As Karen brought up, this happens, I don't think it happens a lot, but it happens occasionally. Is there a fine system or something when developers go outside the boundaries? This is the second property that's come before the Planning Commission in the last month. The other one was they built inside next to that another residential house that encroached upon that, and the Planning Commission also had to do a variance in order to grant a side yard setback. Is there a penalty, or what is the process that ensures developers or builders are building within the required lot line?
So this is an item before the Zoning Board of Adjustment, and before the Zoning Board of Adjustment comprised the Planning Commission members and was an independent board. As Steve can attest to, this was common practice. If they had a meeting, it was typically because somebody wanted something that was not yet built, but in many instances it had already been built and they were seeking forgiveness. Over the years, and it would kind of cycle through this, we have these and we discuss whether or not, especially on commercial development, that we should have a survey and have it staked so that they're building exactly where they've indicated on the site plan that's been approved by the city staff that they will be located. But there's always opposition to that. There's a cost factor to that. That gets passed on to their customers. And so to date, council has not supported that we obtain and can require a survey for a building permit that's infield or an as-built. Many communities, before you get your certificate of occupancy, you bring in an as-built that would show exactly where those structures are. And then the issue is put to light there, so you don't get that certificate of occupancy. There's no fine for it. I guess the punishment is you have to go before the Zoning Board of Adjustment. And in doing that, you have to meet the criteria sufficiently for the Zoning Board of Adjustment to grant the variance, but there's no fee or fine associated with it.
So with the history of the Zoning Board of Adjustment generally always approving these, it's just ask for forgiveness. I mean, they can continue building outside the parameters because I don't think there's been very many incidents. I can't think of one, but I haven't been privy to a lot of this information just the last 3.5 years, but I can't think of one where they made the structure be reformed or taken 2 feet off of it in order to make them in compliance. Once it's built, there really is no punitive way to make them conform.
Madam Chair?
Yes, Vicki.
There actually have been instances where it was too much of an encroachment, especially if it's a carport on a residential lot. They've had to remove that part of the structure. It doesn't happen often, and we don't see a lot of variances overall for the city. So you're right. Once the structure's up, the cost to the property owner, it's sufficient enough. It's difficult for those requests to be denied. It certainly puts them in a hardship if that's going to be the requirement. The difference would be if it does impact someone's, an adjacent property owner's enjoyment or access to their property, or if it creates a safety issue, such as if this had encroached out into the right-of-way to an extent, and we needed that right-of-way for a future improvement. We would have pressed upon the Zoning Board of Adjustment that this one would be injurious to the neighborhood and the public as a whole. In this case, luckily enough, we have sufficient right-of-way. We could vacate it. Planning Commission recommended to do so, and it minimizes the impact to the neighborhood. But I do appreciate the conversation today. Certainly we don't want the message out to the community, just build it and go seek forgiveness instead of permission. And so for that, thank you.
And thank you, and that's pretty much what I wanted to get on record is if this, like I said, I believe it doesn't happen that often, but if we start seeing it increasing in the more and more and more, I think maybe the city needs to take a look at it. Thank you. Thank you, Madam Chair.
Thank you. Steve?
I agree with what Vicki said. This actually does happen quite a bit. It happens usually, like you said, with carports, fences, and I can remember the last one where they actually built a fence closer to what we had allowed them, but somebody from the city actually had seen it, and we did make them dig it up and move it back. It's harder when you got a structure, when somebody builds a house, and it's kind of frustrating because 5 feet's quite a ways off. I'm not sure how you get that far off being professionals and you do this every day of your life. And, you know, I really have a hard time with that, and you've heard that out there. Just build it and ask for forgiveness, and I think that does happen. And I think maybe the council should take this up and maybe visit about it, because if you're privy to what happens here at the zoning board, then you'll begin to see that this is not that uncommon of a practice. And in the public, you hear, yeah, just build it. They'll forgive you. And I think we really do need to take a look at that and maybe come up with something that makes it a little more difficult to just do that.
But I'm going to make a comment. I will not be voting for this, and the reason is because I have a pretty good eye. I noticed when a picture was framed, and I know this is a minor story, but I noticed when it was 1/8 of an inch off, and I had them redo it. And I'm sorry, I think people should be able to tell when it's over a foot. So I will be voting against this. Anyway, the motion was made by Steve and originally seconded by Eric, and he continued his second. So all those in favor, please say aye. Aye. Opposed? Aye. Thank you. Item number 4.
Good morning. For those of you who don't yet know me, I'm Jess Rogers, Assistant City Attorney. Item number 4 is an appeal by Epic Outdoor Advertising of the city staff's decision that their use of full motion video on their public purpose signs is in violation of the sign code. Now, to give you just a little bit of brief background here, back in 2005, Epic built 4 electronic billboards under the public purpose exemption in the sign code that existed at that time. At the time, there was some dispute. At first, city officials said that this didn't qualify as a public purpose sign. It went before city council, and they ultimately determined that if Epic agreed to devote 12 minutes of every hour to public purpose advertising, that it was a public purpose sign, so this was allowed. That's only relevant because in 2005, under the then existing sign code, public purpose signs were allowed to use animation and full motion video. And that was the case until 2010. City Council created an ad hoc sign code revision task force to look at the entire sign code. And throughout that process, one of their recommendations was to prohibit animation and full motion video on all signs, whether they be on premises, off premises, or the existing public purpose signs. Their recommendation was very specific that they intended for this prohibition to also include all the existing public purpose signs. That change in the sign code went through in 2012. From that point forward, continuing to the current day, animation and full motion video are prohibited on all signs. When it came to the city's attention, I believe it was late this spring that Epic was continuing to use full motion in some of their advertisements on these signs. We sent them a letter saying, you're in violation of the sign code, this must cease immediately. It is that determination by the city that they are currently appealing. I'd be happy to answer any questions. I know that Epic is here as well.
I have no questions. I do have some speaker request forms. Tony Crawford.
We may be one item ahead. I may have come to speak about the Freeland Meadows.
Oh, okay.
We just
Sorry.
got the wrong number.
Okay.
I'll be back.
That's
Thank you.
number 4 on Planning Commission, Madam Chair.
Right.
Okay.
Okay, thank you. And I will make a comment before I make the next person. When you speak, we have several people who want to speak, and we really appreciate that. So that is important to us to get all the information. But one of the rules we do have is that if someone has spoke to the topic you're going to speak on, you can say talk on that topic, but don't say the same things, because we've already heard them and we take them very seriously. Deborah Jensen.
Good morning, Chairwoman Marchand and members of the Zoning Board of Appeals. My name is Deborah Jensen. I'm a business owner in Rapid City, also a member of Scenic Rapid City. It seems to me that Epic Outdoor Advertising is telling the city of Rapid City that they are special, have always been special, and expect to continue to be special. Every business is required to apply for and purchase a sign permit before the hole for a sign is dug. The old adage that we've been talking about, is better to beg forgiveness than ask permission, is normally not that well received at City Hall. But if you place yourself in a special category, you may believe that you don't need to ask or beg. In Epic's case, 10 years ago, the attorney argued that the special category of public purpose did not require a permit. The special category also did not specifically forbid full motion or animation at that time. Since then, billboards have been springing up seemingly like mushrooms overnight. Finally, 5 years ago, the citizens of Rapid City took action. Through a citizens' initiative, 66% of the voters said enough is enough to billboards. At the same time, an ad hoc citizen task force labored for months to put forth a sign code that was fair to all businesses and citizens alike and took into account road safety as well as aesthetics. 3 years ago, Rapid City specifically prohibited full motion and animation, even for special categories. Now, I should note that Terry Nelson and Doug Rumka of Lamar Outdoor Advertising have repeatedly stated through the years that Lamar billboards have not and will not run full motion animated video. And to my knowledge, Lamar does not have any billboards placed in the special category of public purpose. However, they also provide nonprofit public service ads. So how special is the category in which Epic Outdoor Advertising has placed itself? That a law clearly made by the citizens and the elected officials of Rapid City can now be superseded. Please vote in favor of what Rapid City attorneys have recommended to you and what the citizens of Rapid City have placed into law. Thank you.
Thank you. Lisa Modrick.
Good morning. I'm Lisa Modrick. I'm president of Scenic Rapid City. I also served on that ad hoc committee many years ago now, and it was comprised of about 15 businesses and citizens, and it was a variety of people that came together to really research and help develop an ordinance of sign codes that could be a little clearer to read and to define, so that what we're talking about today, an appeal, could be looked at, viewed at, see the ordinance, see the law in place, and have a great understanding that this was what the will was of the ad hoc committee as well as of the citizens, and that was to put the regulations on this type of sign, and it's regulations that are reasonable regulations. It is in your hands to uphold, and that's what my request would be as both a citizen of Rapid City, somebody who loves this beautiful city, and speak for so many that keep saying, keep going before you, because we've got to make sure, as Councilwoman Scott had stated, that we stay on track and we don't pull something and put it into a process of appeal and move forward, because the action of today is going to carry with you tomorrow. It's going to carry with you in a decade, as we're finding, and it's going to be the future. So we hope you hold strong, because you're our zoning and you're our planning, and we're counting on you to go forward with what the citizens of Rapid City want, and that's reasonable regulation and enforcement of the law. And one other thing I'd like to add, as City Councilwoman Scott had mentioned, Do we have penalties strong enough? I know that this was stated that it's been going on since April as defined in complaint. So are we really putting the strongest of are we putting our foot down and saying, this is what happens if you break the law in Rapid City on this particular ordinance? So you may also need to address that as well. It would be very easy to turn the lights off if they break the law.
Thank you. Mark Kwasny.
Good morning. Thank you for allowing me to speak today. My name is Mike Kwasny. I'm a resident of Rapid City, and I've spoken before on billboards. I thank you for any work that you do on this. We are at a crossroads again where, you know, I don't know if anybody read the paper this last week where it went, and Rapid City has the right to go forward and make decisions as to how our city looks, and Full Motion is one of those decisions. You know, if you look across down I-190 and you see all those billboards that we allowed to go in along the interstate, I don't know of anybody that really thinks we need that many billboards, but can you imagine if all those were put into Full Motion? We'd have quite the mess. Anyhow, go forward. I hope you vote to keep this as it is and keep the Full Motion out. So I appreciate all you do. Thank you.
Thank you. Mike Sabers.
Good morning. As Paul Harvey said, now for
Introduce yourself, sir.
Mike Sabers. I am the attorney for Epic Outdoor Advertising. I actually figured I knew most of you, but I apologize for not introducing myself. As Paul Harvey said, now for the rest of the story. There's a legal issue on a specific point of law. And when I had my conversation with the city attorney, I said, you know, we can go and have a judge decide it. And they said, no, we want to go through the channels. And I said, that's just fine. And that's why we're here. But let's not forget, there is one legal issue before this board. It doesn't have anything to do with the history and the same speeches we've heard from Scenic Rapid City for the last 6 years. It really doesn't. This is a legal issue. And here is what the legal issue is. In 2005, and this was submitted to this board by the city attorney, in 2005, my client's billboards, public purpose boards with animation, were legal. The city council approved them. My client has been running these boards in the same form, with the same type and kind of advertising since 2005, and that includes animation. Make no doubt, animation started in 2005. It has never ended because it was part of the ordinance that allowed it. It was Ordinance 4030 back in 2005. Then the city council said you will continue to run 12 out of 60 minutes on these public purpose boards. The city recently asked for evidence and proof that my client has continued to do that, and it was provided. What I can tell you is I think my client has provided far more than the 12 out of 60, but it is certainly the 20% that is required. You see those ads. My client catches a lot of bad guys for the sheriff's department. My client runs all of the nonprofits here in town and always has. Trust me, if the city thought they could, at the behest of Scenic Rapid City, if the city thought they could have my client before this board on this issue as well, they would. They can't. My client has complied. Here is the issue that this board has to make a decision on. Can you retroactively apply an ordinance to existing legal, non-conforming boards? Now, I found it interesting that the city attorney's letter to this board says they're not aware of any authority that would allow us, my client, to continue to run Motion. With all due respect to the city attorney's office, they did not look very far, because I looked and there are three, count them, 3 South Dakota Supreme Court cases that say you cannot, it is settled law. I'm going to read a sentence from each one of them to you here in a second. But it is absolutely settled law in this state that you cannot retroactively apply a zoning ordinance. And why is that? Let's think of the big picture. Because the way the billboard code is written today, It has changed. The billboard code has changed over the years more than most people change their underwear. All right? My client probably does not have a sign in the air today that complies with the current billboard code. And why doesn't the city require my client to tear them all down? Because they are what the law calls legal non-conforming signs. This is no different. The city cannot retroactively apply because once a person has a property interest in something that was legal when it was made, you can't go back and make them change it. Don't take my word for it. Take the South Dakota Supreme Court's word for it. Interestingly, in a case against the city of Rapid City. Again, the city attorney's office says they're not aware of any law. Well, how about Lamar Advertising of South Dakota versus the city of Rapid City? And I will read specifically from that decision because the issue before you has already been decided by the South Dakota Supreme Court. And here we go. This is a case where Lamar sued the city because they didn't like my client's public purpose boards. They were trying to say that the city was wrong when the city approved them and that my client was not a public entity that could have these boards. This is the quote. This is Justice Konenkamp from here in Rapid City. He is writing specifically to make sure everyone understands the law in the state of South Dakota. In this case, the amended ordinance added a new requirement that only a public body could request the public purpose exemption. However, that new provision could not be applied retroactively because construction of Epic's signs started before the new ordinance was adopted. The law is well settled that construction generally meets the vested rights test. Structures in the course of construction at the time of the enactment or the effective date of the zoning are exempt from the restrictions of the new ordinance. What does that mean? That means that my clients, the city attorney told you, my clients' boards were legal in 2005, in 2006, in 2007, and I could keep counting. But up until 2012, they're not even alleging my client's signs were illegal. In 2012, there was a new ordinance, and it did prevent motion. It cannot be retroactively applied. The other case that the South Dakota Supreme Court talks about, legal non-conforming signs, are legal until, for instance, had my client come to the city of Rapid City and he filed for a permit and he wanted to change the space of it or how it was lit, or he wanted to make a substantial and material change. At that time, the city has the right to bring these boards into compliance with the new ordinance. You think about, use a house for an example. Are we going to go into North Rapid and start affirmatively coming after people whose homes don't meet the existing today's building code? No, we're not. You can't do it with billboards either. In the city, well, it was actually Lamar Advertising again suing this board, the Zoning Board of Adjustment. They talked about legal non-conforming signs and how they are protected from new ordinances until the person who holds the vested right comes to the city and it files an application. Again, if the city can't find this law, it hasn't looked very hard because they were involved as parties in both lawsuits. The last case that all of this comes out is it's the Rapp versus City of Marion case. And that's where all these cases come from. What it says is, in fact, it's always easier to read it so that you know I'm not summarizing. And let me find it quickly. And I will also tell you that I'm very close to being done. Here we go. And it was important enough to look for because it says, this is again the South Dakota Supreme Court in 2002. As it relates to this case, A non-conforming use occurs when the size, use, or location of a structure lawful before the adoption or amendment of a zoning ordinance becomes out of compliance because of such adoption or amendment. Zoning laws may not operate retroactively to deprive property owners of prior vested rights. And remember, the other case says vested rights is when you start to construct it. My client has had these signs in the air for 10 years, operating exactly as they continue to exist today. A lot of people call this grandfathering. Are your signs grandfathered in? My client's signs are grandfathered in. So what changed? Because the city makes some veiled reference in the city attorney makes some veiled reference in their submission that this has to do with safety. Well, if it had to do with safety, my client has certainly been running motion from 2012 all the way through the new ordinance was March of 2012. If this really had to do with safety, wouldn't we have expected or at least wanted our city attorney's office to do something about it in the last 3.5 years? That's not what happened. And now for the rest of the story. This is why we're here today. The last time we were before the zoning board, my client was asking that this board approve a conversion of a sign. It did so unanimously. Scenic Rapid City was not pleased. And I can tell you that I expect some of you got emails and phone calls because the mayor and the city council's office did. And I know this because the city council forwards those emails to my client. I can also tell you that we went in front of the city council because Scenic Rapid City gave the same speeches to the city council on that issue that they did here today and that they do every single time my client wants to do any business in this city. And what I'll tell you is the council approved it unanimously. And after that, the emails picked up and the calls picked up and the harassment picked up. And the city attorney's office apparently thought that it was easier to try to appease them than have to deal with this. That's what really happened. Because if it really had to do with safety, the city attorney's office wouldn't have waited 3.5 years. If the law wasn't, you can't retroactively apply an ordinance, the city has certainly known that we've run motion for the last 3 years. Why did they wait? They knew. They allege it's safety. No, it isn't. My client, through the last 10 years, as these complaints have come in, has said, please identify one car accident that has happened in this town as a result of motion. No accident, no evidence, no facts have ever been provided to him. So where are we today? We're in another lawsuit. We're in another lawsuit because Scenic Rapid City has called and harassed and pushed their way through. You want to talk about recent litigation? I'd say there was recent litigation where the city attorney's office got into another matter where there was intense pressure for them to proceed and it didn't work out so well. My client shouldn't have to go through the city council to the court, to the next level, and ultimately to the South Dakota Supreme Court so that the justices of that court can say exactly what they told you, what I just read to you from their case. You cannot retroactively apply a zoning ordinance to an existing use. If my client comes to the city and wants to do things with those boards, they may have the right to do that. In the end, you should reverse the determination of the city attorney. My client has actually been threatened with jail with this because he's continuing to do what he's done for the last 10 years. You should reverse the city attorney's determination. All you need to do so is to say this is a legal, non-conforming use, and it reverses it. And until such time my client comes to the city with an application or a permit, he can continue to operate as he has since 2005. It was legal at the time, and it remains that way until he does something. Not the city, the Scenic Rapid City just continues to harass until they push the city attorney's office into doing something that the city attorney's office should know better and know the law. That's my client's position. I appreciate, I'm sorry about the emotion, but every single time my client does something like this, we have the same 3 individuals giving the same 3 speeches. I would tell you there's probably no industry in this town that's more criticized than this, but the last time I checked when I drive into the city of Rapid City is a lot of the businesses, my friends and people in Rapid City, live on are advertised on those boards. You look at the people who advertise on those boards, and if you think those people don't like advertising, then I think that's wrong. There are two sides to every story, except for this one. You can't retroactively apply an ordinance. I will answer any questions the board will have. Otherwise, I bet you'll appreciate it that I'll tell you I'll go sit down.
I do need to make one statement, and this is just from me.
Yep.
But on the Planning Commission, we do not take any phone calls. That is done. You can send us letters and things like that. I've never received a phone call or an email that isn't appropriate. And if something comes, it goes to the Planning Commission, and then it's sent out to us. Now, I can only speak for myself, but I've been on the Planning Commission for a significant number of years and have never received. So I need to clarify that statement because I do not want the public thinking that is how we operate. And so we need to make sure that people know that.
And I don't want to impugn this board, but I know that certain city council members have forwarded emails to my client, and so I didn't in any way mean to impugn. I'm just saying that an intense amount of pressure was applied in this case.
This is the Planning Commission.
I understand that.
Okay.
Nope.
Carla, do you have any comments you want to make at this time?
I don't. I guess I would say that this is an appeal of a decision of an administrative official concerning the zoning code. So your options are to uphold the staff's determination, to reverse it, or to take any other action that you feel like is appropriate. It's a little different than a variant situation where you have to consider certain criteria. In this case, it's just a matter of whether or not you agree with staff's determination. If any of you have any questions for me, I can certainly answer them.
Steve has a question.
Yeah, you've heard what he said up there about the law and about the Supreme Court. So I guess I'd like our legal counsel to come up and speak to that issue.
I'll let Jess Rogers handle that.
Thank you.
Thank you, Madam Chair. I would just like to clarify, nothing is being retroactively applied here. He cited case law saying that you can't retroactively apply ordinances. He's correct. We're not doing that. No one is saying that full motion video was illegal until the law changed in 2012. A retroactive application would be if we were saying since 2005 to now that behavior is illegal. We're not saying that. We're saying we changed the law and now it's illegal and now your behavior is in violation of our ordinance. I would also just like to clarify, he's confusing two issues. There are legal nonconforming structures and legal nonconforming uses, and he's kind of blended them together for you in his presentation. Legal nonconforming structure is really what he was talking about with the houses in North Rapid if we were to bring them all up to code. The reason you're not allowed to do that, to change like your building code and then retroactively apply it, is because it would cause great expense to people. That makes, I think, common sense that we're not going to, with his signs, for example, they are legal nonconforming structures. We can't change our ordinance and change the sign structure, the size, the location, and make him, and apply those to him retroactively, because that would essentially cause his client to have to tear down their signs and rebuild them to the new code. That is what's not allowed. A legal nonconforming use is a very different thing. Generally, legal nonconforming uses are where you have an area of town that's zoned residential and we decide to allow certain businesses to operate. If we were to, and we do that now, you can have certain home occupations. If we were to change that zoning ordinance to say, you know what, even small home occupations, we don't like them, we're going to outlaw them. A retroactive application would be, you know, all those people who are existing, had their home businesses, if we were to say you have to get rid of those immediately. Now, legal nonconforming uses are very different because they're disfavored by the courts, okay? Courts like giving us the ability to change the uses over time. What they don't like is when you completely are going to wipe out someone's livelihood. Like in the example I gave, if you had someone who was running a small business out of their home, but that was supporting their family, the courts probably wouldn't allow us to say, we changed the law today you have to get rid of that. But what they would allow us to do is sort of phase them out in a way that was not economically harmful to that person. In this case, there's no real harm. We're not saying you can't use the signs for what they designed for. You flip a switch and the animation videos go away. Okay, there's no great expense to Epic. Legal nonconforming uses are generally disfavored. There's no real hardship here. So that's a very different case than the examples Mr. Sabers was giving where we're going to make someone rebuild their entire home up to a current code. If you have any questions on what he said, I'd be happy to answer.
Eric?
One other part of that response from Attorney Sabers was regarded the zone that you can't retroactively apply a zoning ordinance. Is sign code technically a zoning ordinance? Is it under our zoning ordinance?
Yes, it is.
Okay. So now the issue at hand, how many signs are we talking about here?
There are 4.
4. And we are not talking about any new signs that would be put up since 2012, that we are not ruling on the prohibition currently in code of full motion. We are just ruling on the 4 signs.
Yes, today the issue before you is just on the use on these 4 signs. To our knowledge, these are the only signs using full motion video today.
Okay. Thank you.
Galen?
See if that works. Thank you, Madam Chair. I guess I've heard what I wanted to hear from the city's attorney here, that the uses are very different than the structures, and to me it seems a very easy switch to get rid of the motion video and to keep allowing the static signs. So I guess I'm not comfortable to overturn the city's opinion here. So with that, I'd like to just move to uphold the city's position on this.
Second.
Motion's been made and seconded to uphold the city's decision on this. Vicki? We do have some more speakers I will be calling on. Okay, Jan?
I served on the Sign Code Board of Appeals when there was one, and there and here on the plan, we're operating as the Zoning Board of Adjustment right now, but the Planning Commission frequently comes up with the problem of signs, and granted, we only come up with the problems when they're a problem instead of conforming, but every single time I've had to vote on signs, they were legal, non-conforming, and we voted yes because they were improving. They were asking to improve the situation, to make the sign smaller or make the sign more attractive or farther away or whatever, and we traded off the improvement instead of saying no. And that was because the sign companies have long-term leases on the property, and they can continue to do if we don't vote yes, that they can continue to do as they are doing without penalty. And I'm pretty sure that the citizens wanted no motion on signs. I'm pretty sure that the intent of the ordinance was no motion. I don't know about the retroactive problem between structures and actions, but I'd like to see at least once that we voted to do what the citizens in the ordinance wanted to do and see what happens. It's not clear to me this goes to the state Supreme Court. I believe it actually goes to the federal district court, doesn't it, for appeal?
Arla?
No, it would go to circuit court here,
Okay.
state court.
Anyway, I'd just like to see, if we're going to lose, let's find out we're going to lose, instead of every time having to compromise because we're afraid we're going to lose. So I'll vote in favor of the staff's recommendation.
Steve?
The comment was made that there would be no loss to them, and I've been on the city council and I've been on the planning commission, the variance board, and retroactive is something we've never done on anything that I can ever recall, because retroactively is harming somebody. And I'll put it this way, if there's only 4 of them out there, and there are only 4 that can do animation, because I agree with, I believe the citizens don't want the animation, and I believe they voted that way, but you already got 4 out there that are doing that. So that makes them incredibly valuable. They're the only place that those that want animation can go to. So you are going to affect their profitability on that, because now those have become very, very valuable. Anytime we've gone back and say, you can't do something, we make a law, I agree with you. From that point on, nobody else can have that. So it made those who have it, it is now more valuable. So I have a hard time saying we're just going to push a switch and it's not going to affect them. You're going to push a switch, and yeah, they can continue to do their billboards, but they can't animate. Nobody can now. And so you have an issue there. So I do have an issue. I think this will ultimately be decided by a court. It's not going to be decided here, because I'm assuming if this board votes it down, it's on its way up. But I'm just saying that you can't say it doesn't affect them in the pocketbook, because those signs have become very valuable. Thank you.
Karen?
I seconded the motion because I believe that our attorneys have done the right thing, and they have stated the fact that this is not a taking as far as making them remove the billboard, do those kinds of things. This is a stipulation that the council has made an ordinance to change that. Change that. Our ordinance is to say that there is not allowed for motion on a billboard, and I think that is the correct answer. I think that Epic still has a full use of their signs. I think that they would now be in the same setting with everybody else that makes signs, and we're not giving them a special privilege to do something that nobody else can do. I think they'll all be the same. And I feel strongly about billboards anyway, and I am definitely going to support the motion to keep the legality of uphold the determination that the city has made, and that Epic's full use of full motion video is in violation of the sign code and has to cease. So that I support that strongly.
Amanda?
Thank you, Madam Chair. I'm not a voting member of the zoning board. I'm just a liaison from the city council. But in listening to the discussion today, and I do appreciate the city attorneys, both of them, weighing in on this issue, the explanation that was given as far as the difference between construction or physical versus the use of a property within the zoning code. What started my mind, and just something that I would appreciate the zoning board considering when they're thinking about voting on this, is the attorney for Epic Sign stated that, and according to law, you can't retroact anything that affects physical, legal conforming structures. What we're talking about in the zoning ordinance is digital. There has been great enhancements in 10 years in the digital world. And so one of the things he kept bringing up was that the Planning Commission or Zoning Board of Adjustments could consider anything else if they were going to change the structure. Something I think you should consider is, digitally speaking, in 10 years, with as much enhancement as digital photography and the technology and displaying stuff has changed, if you're going to allow technology to last 10 years, I would think that if we really need to take a look at it, anytime they upgrade a motherboard, anytime they upgrade their circuitry, anytime they upgrade the display or the display of the lights, that would almost fall into that, well, they're really applying or they're really changing their technology. So for him to say that they've been the same for 10 years, I question any piece of equipment that could last 10 years without any type of modification. So the digital world side of this and the enhancements, and that's what the citizens of Rapid City came back with, saying they didn't want motion, that has changed over 10 years. It may not have changed in the last 3 years to the billboards, but I have a hard time believing that the billboard hasn't undergone some type of upgrade or maintenance in that amount of time. So Those are just the thoughts that I've had listening. Just wanted to pass them on. I am a non-voting member of this board. I'm just representing the city council. Thank you, Madam Chair.
Brendan Casey.
Will the chair allow me to speak on my client's behalf?
Sure.
Okay. With all due respect, the distinction that has been discussed by this board in the last 10 minutes doesn't exist. I don't know, lawyers laugh that we don't have a lot of law in the state of South Dakota, but we have law in this issue, and I read it to you. The city was a party. Lamar was a party. Actually, the justice who wrote the comment was Justice Konenkamp, who came from Rapid City and sat on the court for 23 years. Use. Mr. Ollinger, my client's signs are very valuable. They are the only 4. He has contracts in place that extend well out into the future that will be breached. Or he can comply with and go to jail, according to the city attorney's office. When he breaches it, he's going to suffer damages. And yes, these are profitable signs. And when he suffers damages, you have taken away his property right. A property right that was legal when it came in and remains legal today. My client has no choice. This is no different than anyone else who has a business in this town and must protect it. My client has no choice but to go to council, and then the circuit court, and then the South Dakota Supreme Court. It's what Lamar had to do. And the South Dakota Supreme Court has already told this board what the law is. And my client shouldn't have to pay me to go get the same answer to the same question that has already been answered. But it's going to happen after my client is forced to breach his contracts. He's going to suffer significant damages, and there's going to be a taking. Thank you.
Thank you. Okay, the motion's been made to support staff's recommendation and uphold the determination that Epic's use of full motion video is a violation of the sign code and must cease immediately. All those in favor, please say aye.
Aye.
Opposed?
Aye.
Eric and Steve voted no. Motion passed. Are there any other further items for the Zoning Board of Adjustment? I'd entertain a motion to adjourn.
Move to adjourn.
Motion's been made and seconded to adjourn. All those in favor, please say aye.
Aye.
Opposed? Motion passed. We will now commence the City of Rapid City Planning Commission meeting for the October 8th, 2015. Consent calendar. Items 1 through 3 have been placed on the consent calendar and may be approved as a group. Action will be taken on all consent items in accordance with staff recommendation by a single vote. Any item may be removed from the consent calendar by a planning commissioner, staff member, or audience member for separate consideration at this time. The findings of the Planning Commission are recommendations to City Council. The City Council will make the final decision with the exception on the following items. Item 2, 15 PD 027. Item 3, 15 PD 036. The Rapid City Planning Commission's actions on these items are final unless any party appeals the decision to the Rapid City Council. All appeals must be submitted in writing to the Community Planning and Development Services Department by the close of business on the 7th full calendar day following action by the Planning Commission. Are there any items 1 through 3 that staff would like removed?
No, thank you, Chair.
Any items by the Planning Commission? I would entertain a motion.
Move to approve.
Second.
Motion's been made by Steve and seconded by Eric to approve the consent calendar items 1 through 3. All those in favor, please say aye.
Aye.
Opposed? Motion passed. We are now beginning of the regular agenda items. Item number 4.
Good morning. Kip Harrington, Long Range Planner. Item number 4 is a comprehensive plan amendment to amend the major street plan by realigning an arterial street. This street is the future extension of North Lacrosse Street. A little background for you. In 2008, there was an amendment done to the major street plan which shifted this proposed alignment to the west to accommodate some development plans. In the meantime, that property that was up for development has been sold. The new owner has come back and wants to realign the street back to somewhat closer to its original alignment. Take you through some slides here. The box in yellow is the outline of the area of the proposed realignment. The zoning map, which shows the zoning in the area. It's a mix of city and county zoning. This is the existing current major street plan, which shows the future extension of North Lacrosse Street, jogs to the west, and then ties in with West Nike Road. And then this was the amendment as brought in by the applicant. In the past few days, since this map was created, there's been a little bit of a flurry of activity between meetings with property owners and city staff, and there's been some compromise on this alignment. One of the property owners who was in attendance, Mr. Tony Crawford, had submitted a letter of opposition to how this alignment affected his property. Since that has occurred, the applicant and his representative have met with Mr. Crawford, and they have come up with a compromise on how that would less affect his property. After that happened, they brought back a revised alignment, which city staff has taken a look at, and city staff made a couple minor adjustments to it, and we have since come to a consensus that this is the proper alignment, and I can show you a map on that, but it's going to take me a minute. Folder. Sorry, I hit the wrong folder there. And once again. And as you can see now that the alignment, which previously came up and jogged out to the east a little bit and then came back, is now coming up in more of a straight line along the existing quarter section line. So that has been the consensus that has been done between the property owners, city staff, and the applicant themselves. The applicant and his representative are here for any questions. We also have some property owners here if there are any questions for them. City staff recommends approval, and I am available for any questions.
I'd move to approve. Motion's been made by Steve and seconded by Mark. Yep. To approve. We do have a speaker request from Tony Crawford.
Good morning. My name is Tony Crawford. I'm the landowner that was referred to by Mr. Harrington, and I have, as he mentioned, participated in the recent flurry of activity, and it's been very productive. I want to just compliment the principals in the Freeland Meadows subdivision for being willing to reach out to me and to make the compromises and to involve their engineer and to resolve the complaint that I had. And I had shared earlier that I don't come here today in any way recommending the proper street alignments. That has been the topic of study and discussion for years with these gentlemen, and they know far more than I do. My concern was the adverse effect, not this current amendment, but the just previous amendment had. It had an adverse effect on me. That was shared with the developers. They then accommodated those concerns and have now proposed the street down the property line, more or less. So I'm here orally to withdraw my objection to the developer's request. Mr. Harrington asked that I attempt to do this in writing yesterday. I was unable to do it, so I hope that the oral withdrawal of my objection to the developer's proposed street plan is sufficient.
Thank you very much.
Thank you.
I see no other comments. All those in favor?
Aye.
Opposed? Motion passed. Item number 5.
Thank you, Madam Chair. Item number 5 is an associated item to the item that you just discussed. It's a preliminary subdivision plan to create 34 single-family residential lots and 14 townhome lots as a part of the Prairie Meadows subdivision. When we looked at that application, we noted that, I'll just pull this up real quick. We noted that along that eastern lot line, North La Crosse Street was shown as per the major street plan. So we put this file on hold. We suspended it to allow them to visit with the staff and ultimately with some of the area property owners. And thank you for your discussion on the item previously. With the motion that you just made, it opens the way for you to take action on this application, which does not show that street up against this east lot line in compliance with where you've just relocated North La Crosse Street. So that's a plus for this. It's the area that's shown in hatched. The northern portion is zoned low-density residential, the southern portion medium-density residential, and as I noted, it is a mix of single-family and townhome development. Country Road is an arterial. You can see that was the previous location of North La Crosse Street, and then the green is West Nike Street, a collector street. The plat comes in 2 sheets because it's several lots, and it lays out in that hatched area. This is looking west on Country Road and east on Country Road, north on Nike. Looking into the site, they're certainly maintaining it in a very good site until they come forward with the future street construction. Looking more northeast into the site, you'll see that street extension is ready to go. Again, looking more north and east. This is looking on, I believe, Eli Drive, north or south back into the site. Looking back on Eli Drive and looking northwest. So with that, we are recommending that the associated preliminary subdivision plan be approved with the stipulations as identified in the staff report.
Jan made the motion to approve. Is there a second?
Second.
And Eric seconded the motion. All those in favor, please say aye.
Aye.
Opposed? Motion passed. Item number 6.
Item number 6 is 15 PD 032, a major amendment to a plan development to allow an on-sale liquor establishment in conjunction with a salon. This was continued from the previous meeting. Correct signs weren't posted on the property due to staff error. That's been fixed. What is being proposed is there's a salon with 8 chairs called Sabel Salon at Tuscany Square. And we'll start the presentation. It's located just to the east of this building. Tuscany Square is an existing commercial development, zone general commercial district with a planned development. The last major amendment that was done on this property was required to reduce the parking to allow the salon to go into the space that it's in. It's along Omaha, which is arterial street, and this is a big commercial corridor in the city. Future land use is downtown district. Where the X marks the spot, that's the location of the salon within the Tuscany Square development. What they're proposing to do is serve wine to customers that are in getting a pedicure or manicure. Looking at the property and the signage and the space, the row of other uses in the commercial structure on the south side of the property. Those are the correct signs posted in the window, planned development, and an on-sale sign for the liquor use. This is looking at the rest of Tuscany Square on the west side of the property, looking from inside the property to the east, and Goodyear Tire. Again, this is a commercial corridor. Looking north on the, forget what, that's 3rd or 4th Street, and to the south. And this is along the south side of the property, looking west back towards Avies Feed and Seed, and in the to the east. And this is looking north on Omaha, to the east on Omaha, and to the west. And there's also a bank located on that same block. And this is a view of it. Since this is a commercial corridor, an established commercial corridor adjacent to the downtown, and the proposed on-sale use is in conjunction with a salon and isn't going to be, they wouldn't be able to have beer and wine with a, without the salon use. Staff recommends that the major amendment to allow the on-sale liquor establishment in conjunction with the salon be approved.
Motion's been made by Steve and seconded by Karen to approve. All those in favor, please say aye.
Aye.
Opposed? Motion passed. Item number 7, please.
Thank you. Item number 7 is 15 PD 033, final plan development to allow mini storage units in the general commercial district. This item was continued from the previous planning commission meeting to allow the applicant to meet with staff. The meeting that the applicant had with staff occurred on October 5th, or Tuesday or Monday of this week. Based on the conversations that the applicant had with staff, they're going to ask that this item be continued to the October 22nd, 2015 Planning Commission meeting to allow them to take another shot at the design of the site. And that's staff's recommendation. We're available for questions.
Karen made the motion to continue to the October 22nd meeting, and Eric seconded it. All those in favor, please say aye.
Aye.
Opposed? Motion passed. Item number 8.
Staff's recommending that item number 8, 15 PD 035, be continued to the October 22nd meeting. Notification letters, which needed to include everyone within the planned unit development and 250 feet around the planned unit development, were not mailed out. It was just 250 feet around the property, and it needed to include everyone. So in order to allow that notification to be sent out, and staff will do that, staff recommends that the item be continued to the October 22nd meeting.
Jan made the motion. Is there a second?
Second.
Steve seconded the motion. All those in favor, please say aye.
Aye.
Opposed? Motion passed. Item number 9.
Thank you. Item number 9 is 15 UR 022, a conditional use permit to allow an on-sale liquor establishment in conjunction with a casino on approximately 0.31 acres of property located at 2820 West Main Street. The applicant represents the existing King of Hearts Casino that's located at, I believe it's 2900 West Main Street. The applicant is proposing to relocate that existing casino to the structure located 2 blocks to the east. They're not proposing any new casino, and there's no increase in density of casinos that's going to be affecting the overall area. Let me take you through some slides. This is a area that's fairly well known to most residents of the city. Lower right-hand corner here is the old location of Shotgun Willie's, just to put it in reference for you. The site's been, to the west of that, has been under development for quite some time. So we're excited to see some new use coming in here. The zoning on the property is general commercial district, and there is some medium density residential district located to the north of the property. It's in a mixed-use commercial area. That area to the south of West Main Street is the National Guard camp, and it's located on a principal arterial street. So look at the proposal. The applicant is proposing a 2,000 square foot building to house the casino. They are proposing only to sell beer or malt beverages, and that's the extent of the use, the on-sale use. One thing to note here is they are proposing an access through the adjacent property to the west. When the property to the west comes forward with their development, they will need to secure an access easement as a part or prior to issuance of a building permit for that proposed layout. Elevations of the property, including the location of their vinyl canopy, which will also serve as their signage. If you're familiar with the King of Hearts and the Queen of Hearts casinos that exist today, the signage will be very similar. Look at the landscaping plan. They do comply with the required number of points, and those points are located primarily on the West Main Street side, so they're providing a nice vegetative buffer and some nice streetscaping. Look at the sign posted on the property. As you can see, substantial redevelopment occurring in the area. Look at West Main Street to the east, West Main to the west, National Street, where they will be taking that western access easement, and across the street at the National Guard camp. And then one more look, or two more looks into the inside of the property. The requested application does meet all the requirements of the zoning ordinance, meeting all the setbacks, parking, lot coverage, building height regulations, and as such, staff is recommending that this application be approved. There are representatives from the of the business in the audience to answer any questions if you have them. Staff is available for questions at this time.
Karen?
My question really goes to the King of Hearts location today. Once that building is, or once that use is moved to this other location, what happens to the license for that? I mean, the license will go, I'm guessing, with the King of Hearts, but the use, the conditional use permit that was allowed on that property, does that be removed then?
Yeah.
On the current property?
Vicki?
Yeah, looking at how the conditional use permits were approved back in that time, that conditional use permit stays with that property. So if someone else comes in, they would have to get a liquor license from the city council, and they would have to operate in conjunction with whatever was approved as a part of the conditional use permit. And if they don't choose to use the CUP, those were typically written back there too, that if the use ceases for a period of 2 years, the use expires.
Okay, so another casino could come into that current
Right.
location?
Yes.
Okay, thank you.
Steve made the motion to approve. Is there a second? Second. Gillen, second. All those in favor, please say aye.
Aye.
Motion passed. Oh, any opposed? Since I heard everybody's voice. Motion passed. Item number 10.
Item number 10 is a final plan development to allow an assisted living facility located on off of Highway 16 and Table Rock Road. Aerial view of the property. This is the former location of the Embers Restaurant, and then on the north side there used to be a motel. Staff has worked over the years with many people looking at redeveloping individual lots in this area. The applicant has purchased all the lots in the yellow square. Previously, they vacated the Northview Drive and Silver Nugget Drive right-of-way, which was before the Planning Commission, and that's been approved. And they've also vacated a few easements, which are administrative applications on the property. Property zone general commercial district with a planned development designation. An assisted living facility is a conditional use in the general commercial district. Future land use is mixed use commercial. And then US Highway 16 is an entrance corridor. and is a principal arterial street on the city's major street plan. Here we have the layout for the facility. On this side, we have an assisted living and memory care one-story building with a total of 61 units. On the connection here to the west or north side of the property will be a three-story structure with 60 units of transitional housing as part of this whole facility, this assisted living facility. There is one exception that's being requested, and that is that on this south property line, it abuts a residential district. Planning Commission has seen plan development applications and approvals for townhomes and single-family development along Table Rock, south of this. So the property to the south is a residential district, which requires a 5 to 6 foot ornamental screening fence. The applicant is proposing to provide a screening fence on a large portion of this side abutting the property, but on this southeast side here, the slopes are such that putting a fence in it wouldn't have much of an impact on providing that buffer. So instead, they're proposing that in lieu of the fence, putting in some landscaping. One of the stipulations of approval is that that landscaping be evergreen and not something that would lose its leaves in the fall. Elevations of the proposed facility, showing what the fence would look like that along that south property line. Sign for the that would be on Table Rock. Let me go back to that landscaping. So one of the stipulations is that upon submittal of a building permit, a revised landscaping plan be provided. We want to spread out some of these trees on this west side and get them along the street side here. Give it the property a little more aesthetic pop to it. The ordinance says that up to 50% of landscaping on the property should be visible from a residential district. So that's where we're getting the muscle to require this revised landscape plan. I believe what they were looking at was in the ordinance, if you're a light industrial district, you can do a irrigated or non-irrigated buffer. This property is not zoned light industrial district, so what they were intending to do wasn't really going to work out. So upon submittal of a building permit, we're going to get a revised landscape plan. It'll still have these evergreen buffer on this southeast side, but try and spread out some of the trees along the streetscape. Looking into the property to the north, sign is posted. We've worked with a lot of people to try and figure out what to do with the old Embers property, and this is a really great reuse in the area and should have a beneficial impact. Looking north along US Highway 16, to the west across Highway 16, we have National American University. This is looking to the south and west, and looking south along US Highway 16. And there is some commercial development still coming on the south side of Table Rock. This is looking south and east along Table Rock, and there is some single-family and townhome development happening out there. And looking along the road, there's a lot of construction still happening. In fact, I believe the old Embers property was used by the fire department for a little bit of training, so it was a benefit to the city as well. So the proposed use is a conditional use. They're asking for the one exception. Staff recommends that the final plan development be approved with the stipulations noted in the staff report regarding the exception to the screening fence and supplying that revised landscape plan.
Second. Steve made the motion and Jan seconded to approve the staff recommendations. All those in favor, please say aye. Aye. Opposed? Motion passed. Item number 11.
Item number 11 is 15 PD 039, major amendment to the plan development to allow an on-sale liquor establishment in conjunction with a specialty store, and this is located in Rushmore Mall. In particular, Dakota's Best Wine and Gifts has a store located within Rushmore Mall. State law says that with an off-sale liquor license, you're limited on the number of samples and the size of samples that you can give to customers. So in order to provide more samples of a larger size, if that's what they're, in order to do that, they have to go through get an on-sale liquor license, which would require the conditional use permit to allow the on-sale liquor establishment. Aerial view of the property showing Rushmore Mall, existing developed area. Zoned shopping center too with a planned development. Future land use, mixed use commercial, and it's identified as a regional activity center. And Disc Drive along the frontage is identified as a collector street with Maple Avenue coming from the south, also a collector street. This shows the location of the shop within Rushmore Mall. It's this dark square inside here. And it's approximately 1,175 square feet. Site plan of the property. View showing the mall. Looking at the rest of it to the east. There are other on-sale liquor establishments in the area along that south side that you've got Red Lobster, Texas Roadhouse, and the Olive Garden. And then within the mall, there's Fuji. So these are all uses in conjunction with a restaurant. So it's not just bars. So also looking at the Olive Garden, looking east along the south property line, looking towards development in the area. East along Disc Drive and to the west. And looking south, you can see across U.S. Highway 16 to the south. And this is looking at the shop within the mall itself. So they're not proposing to sell the wine, to have people drinking in there just to go in there and drink. It's more to sample the wine, the wares that they have, the wine that they have, and be able to offer larger samples as well as, if they want to try more than 3 wines, they can try more than 3 wines. So staff recommends that the major amendment be approved with the stipulations noted in the staff report regarding the use.
Karen made the motion to approve. Steve seconded. All in favor, please say aye.
Aye.
Opposed? Motion passed. Steve has a discussion item.
Thank you, Madam Chair. Earlier today, we spoke about the difficulties we have when people encroach and build something and just say, hey, let's go ask for forgiveness. And as Vicki knows, we've seen quite a bit of that on the zoning board. And I guess I'd just like to make a motion to move a discussion forward to City Council to look at options that we have. I mean, maybe somebody has a fence, does something like that, the fine would be smaller. You take a building, you do something like that, I think it should be a lot more, because these are professionals that are out there, and they do this. They've been doing this, some of them 20, 30 years. And to make a mistake, 5 feet, seriously, I have a really hard time with that. So, Vicki, what would be the proper motion to move something like that forward to the council?
Carla? I'll call on Carla.
Sorry, I don't mean to encroach, but I would like the chance to look into the options and talk about it with staff and maybe bring it to this group, since there have been a lot of questions here today. Bring it to this group first and then bring it on to council. If you want me to go right to council, that's fine, but since you guys are the ones who see it the most, then I could prepare a memo to talk about our enforcement options or the legal options we have when this occurs, and bring it to you in maybe not in the next meeting, but maybe in a month.
Yeah, no hurry, just something.
No, I agree that this is a good discussion to have.
Karen?
Thank you, and thanks, Steve, for bringing that up. I think that's a good idea. I have the same issues that Steve has, you know, when people come in and ask for forgiveness, and it's hard for us to say, well, cut off that building, but yet I can't believe that they don't know that they're wrong when they're building it. I mean, it just doesn't make sense to me. And it's not just today's thing, it's the one we had before, and you know, anyway, I concur, and I thank you for doing that, Carla. That will be nice. I have one other item, too, if you don't mind.
Karen?
When I was at the, excuse me, city council meeting in September, there was a woman there that came and talked about the Dark Skies Initiative, and I know that that's something that we've had on, planning staff has had on their books for a long time to see if we can have an ordinance of some kind. I don't know if that's something that staff has the ability to look at again, but I certainly would recommend we at least look at that. And if you guys could bring something back and see if that's feasible in the next year, I mean, it doesn't have to be tomorrow, but I just think we should go forward with that. That sound all right?
There we go. I think that's in the same realm of what Carla just stated, Karen. Staff would like to visit about that amongst ourselves, look at what other communities have done, see what ordinances can actually be enforced, and then come bring that information back for you folks and see if there's something that we could do for an amendment to the ordinance.
Yeah, that's fine. And I know that there was a booklet at one time back there just on that, so there's a starting of that. So, okay, thank you.
I want to add a couple words. I want to thank all of the legal assistance we had today, because that really helps us for moving forward. And so I thank Carla and everyone that helps us to make the best decision possible for our community, because we significantly care about our community. I want to thank all the commissioners today, because I know the meeting was a little longer, and I appreciate the commitment. It's all my fault, he says. I have had the shortest meeting on record, too. Vicki?
Madam Chair, just as a reminder, at the end of your next agenda, at the October 22nd meeting, you will have the election of officers. So be in attendance, or you may get elected.
Thank you. If there's, I would entertain a motion for adjournment.
Move to adjourn.
Jan made the motion and Eric seconded. All those in favor, please say aye. Opposed?
No.
Motion. Steve wants to continue.
That was too much fun.
Motion passed.